So thanks to everyone who's joining. Just to give you some updates that we're waiting about 3 to 4 more minutes, and we'll get things kicked off for Ajua's Stay Alive and Thrive webinars. So as more people start joining, just give you an update that we're waiting 1 more minute, and then we'll get things kicked off with Ajua's Stay Alive and Thrive webinars. All right, good morning, everyone. And whatever time it is in your area. My name is Ken Field Griffith, CEO and co-founder of Ajua. So we've been running a series of webinars, Stay Alive and Thrive webinars, just to really communicate to the larger ecosystem and community about the things that we could be doing to actually get through this pandemic and also thrive after this pandemic for all business owners and also businesses that are trying to scale within this time. So today, we have a really fascinating guest, John Walubengo. John has a really hefty background of ICT, as first as a founding dean of Multimedia University, and also, he's a contributor to Daily Nation. He's also a lecturer still, and was a member of the task force for blockchain, data protection, and AI for the government. And then now he's joined us to be the chief data protection officer at Ajua. Really fascinating to have John join us today because of many reasons, right? I mean, you've heard a lot of information about data protection, a lot about security, safety, and us as consumers. How is our data being used? And I think this is very important this time because of the pandemic. knowing exactly that, as we like to say, data for good. Everyone is actually tuning into these numbers. We want to know exactly how, the numbers, how the numbers are rising, is the curve is flat, if the curve is flattening, and obviously really having the discussions as far as when are we going to get out of this pandemic based on data, whether it's hotspots, whether the correlations between these hotspots, and even, age groups, which age groups are more susceptible to this pandemic. So there's a lot of data being sharing, and obviously this is the session to actually really talk about these issues and really discuss what this means to us as consumers and also enterprises. So without any further delay, I would like to introduce Mr. John Walobengo to take us through this. And we want it to be very interactive because this is a hot topic, not just because of a pandemic, but previous to that of the Data Protection Act that was launched in 2019. So welcome, John. We're looking forward to an interactive session.
Thank you, Ken. I want to go straight into my slides, so give me a moment, I share it. Is it visible? Can you see the slide?
Yes, it's visible. And just as a bit of housekeeping, we typically take questions at the end, and we ask people to write their questions in the Q&A section at the bottom of the screen. Just type your questions, and I'll be moderating at the end, going through these questions. So the earlier you get your questions in, it's actually first in, first out. So let's get your questions in as quickly as possible. So thanks, John. I'll hand it over to you.
Thank you, Ken. I want to thank the people who have spared time to tune in. I have about 40 slides, but I'll take about 30 to 40 minutes. Then we have more time for Q&A. Why I've been called to talk about this topic is perhaps because I was involved in the government data protection task force that actually gave birth to the Data Protection Act of 2019. So I probably know a bit or a lot about data protection, and I feel it's only fair that I share it with those of you who have spared the time to join us. In front of you is a summary of what I plan to go through. Just basic terminologies. What are data controllers? What are data processors? What are data subjects? This is what the Act refers to, the key actors that are involved in the data economy. Thereafter, we look at the rights of citizens. As we shall see, data subjects are basically citizens. And the obligations of data controllers, basically organizations and enterprises with regard to personal information. Then I'll take you through the key principles that the Data Protection Act is based on, some implications for enterprises, and then how to be compliant as an enterprise. Then we'll conclude and have some Q&A. So we start at the beginning. What exactly is privacy? Privacy can be defined as an individual's right to freedom from intrusion or prying eyes, the right to be left alone. Okay. Privacy could also be defined as the rights and obligations of citizens with respect to how organizations collect, use, or retain their data or dispose of it. Privacy, many constitutions across the globe recognize it as a human right. So many sovereign states have an obligation to protect the privacy of their citizens. I also want to define data security, which is focused on protecting the data from unauthorized access. So essentially, data security focuses on the integrity of data. Is it accurate? Is it reliable? And is it available when it's needed? So when we put the two together, data security and data privacy, then you have data protection. So what this means is that a data protection regime has two components, the privacy component and the security component. More often than not, the privacy aspect deals with compliance issues and favors the consumer or the citizen. So the privacy issues tend to want to protect the rights of the citizens in as far as the enterprises that collect information on them is concerned. The way the enterprise is supposed then to protect the privacy of the consumer is through technical means. That's now the security aspect of it. Now, what types of personal information exist? We'll define two types. There's the normal or the general personal information, and later on sensitive personal information. So personal information is any information that can be about an identifiable natural person. So any piece of data that can identify a human being is considered personal. There are a couple of examples at the bottom here. You have the name of someone, their email address, their ID, their national ID, passport number, telephone number, device numbers, even if you have a mobile phone, it has some device number that is unique to that phone. So that in and by itself is considered personal information, because somebody can use some algorithms to triangulate and find out who owns that device number. Cookies as well. When you log into websites, most software would leave some unique identifier on your computer, so that tomorrow when you log in again, it's able to know how many times you visited the website. So physical characteristics, consumer, financial, geolocation data about human beings, all this is considered personal information. How different is it from sensitive personal information? The sensitive personal information is one that can potentially be used or abused from a discrimination perspective. So yes, it's personal, but it's also sensitive to the extent that whoever collects it can abuse it to a great harm to the user. And these examples for that include medical data, racial or ethnic data, genetic and biometric data, political views, sexual preferences. So if you're collecting this type of data, the Data Protection Act categorizes this as sensitive personal information and accords it a higher level of protection. In other words, it will expect enterprises to put in extra security measures in as far as sensitive personal data is concerned. A couple of more definitions. Data controller, who exactly is that? It's a legal entity organization that collects and processes personal information for predefined purposes. In general, it's any organization that collects personal information. They are considered data controller. But more specifically, the legal definition says a data controller determines the purpose. Why are you collecting this data? And they also decide how to process the same. So they determine what, for example, questions do we want to ask the consumer and for what purpose. A data processor, on the other hand, is somebody or an entity that has been delegated by the data controller to process that information. So perhaps a quick example would be the relationship between Safaricom, the organization, and the M-Pesa kiosk. You know, these people you go to withdraw or to renew your SIM card, whatever the process may be. So the kiosk owner, the Safaricom M-Pesa kiosk owner, is a data processor, while the Safaricom, the entity, becomes the data controller, because they decide that if you want a SIM card, this is the information we need from you. And then they delegate part of that process of collecting information to the data processor, the kiosk owner, the M-Pesa kiosk owner. It gets a bit complicated because sometimes you can have a hybrid such that you have a collaboration between two entities in terms of what data to collect and what purpose that data, why are you collecting that data. Safaricom could also have joint processors. It could be the data controller, but it could contract multiple data processors for the same function. Or you could even have a data processor who works on behalf of Safaricom 50% of the time, and then 50% of the other time, they do their own thing. So they are data controllers in their own respect, because they have independent processes that have no relationship with Safaricom. It's important to get the difference between the two, because in case of a breach, the referee or the data controller would want to apportion blame. By and large, the data controller and the data processor tend to have the same responsibility, but in terms of fines, penalties, the data commissioner may, in case of a breach, find a determination who between the two actually bears the greater responsibility for a particular breach. So who is a data subject? This is somebody who is the consumer, yeah, the person that business enterprises are interested in and collecting information about. So think of a data subject as a citizen that you're engaging in. So depending on your enterprise definition, the data subject could be your subscriber if you're in the telco sector. It could be a student if you're in the academia. Could be a debtor if you're in debt collection. It could be a voter if you are IEBC or the electoral body. It could be a patient if you're a hospital. At the end of the day, it's the citizen who is the data subject. And the data protection regime puts the data subject at the center. I mean, for years, companies have put trade secrets at the center of their data security procedures and processes. But what the Data Protection Act is doing is turning that over its head and saying, yes, protect your trade secrets, but the personal data, can you bring the same level of protection to the data, to the personal data, as it were. So why data protection? Why should it matter? It matters because it's a constitutional obligation, one. Article 31 of the Constitution does recognize the right to privacy. Another reason for data protection is that it's good for business. If your company becomes or goes through the process of being compliant, you find that you expose your internal data processes for scrutiny. And in the process, you are bound or you are likely to improve your processes through the so-called data protection impact assessments. Another reason is that because of something called GDPR, which is the European Union Data Protection Regulation, is very strict that their companies or Europe-based enterprises cannot do business with companies that are in a location that has no sensitivity to personal data. So if you're a European country, company wishing to collaborate with an African company in the data economy, you'll probably want that that company is based either in Mauritius, Kenya, South Africa, or Ghana, just to mention a few African countries that have a data protection regime. So the compliance is good for business in that regard, that it exposes Kenyan companies into opportunities that would otherwise have been not available. If you're still not convinced that data protection is good for you, you realize that non-compliance is costly. Okay, so if you don't comply to the regulations, the Office of the Data Commissioner has the ability to sanction, give penalties to violators. And that means enterprises face compliance and reputational risks. In case of breaches, individual breaches, for example, if your employee sells, personal data because they have access to it in line of duty, but if they mishandle it or want to benefit from it illegally, they face up to 2 years imprisonment, fines, or both. If the corporate is found to have violated those principles, they also face administrative fines that can go up to 5 million or 1% of the annual turnover. The actual law says either 5 million or 1% annual turnover, whichever is lower. In our discussions, we had assumed that it will be the other way around, that it will be whichever is higher. And but as a task force, you put your proposal, but then somewhere along the way, things may change. So we're still discussing how this change came to be in law, but in principle, it's supposed to be 5 million or 1% annual turnover, whichever is higher. So the data subject rights, what exactly does the law accord the citizen? Quite a whole list of rights to access their personal information. Most enterprises do collect personal information, but they don't have processes and procedures to allow the citizen to access what is it that you have collected about me. Okay, so the citizens have a right to that information. They have a right to know how the enterprise is using that information. So it's no longer a question of we've collected your data and now that data belongs to us, don't ask questions. The citizen has a right to changes. If the collected information is in error, you have a right to change. They have a right, the enterprise needs to have processes and procedures to facilitate the changes accordingly. The right to restrict processing, the issue of consent. Before you process my data, I do need to consent, but having consented, the enterprise should also give me an opportunity to, change my mind if I no longer wish that that data is processed. The right to object to decisions purely on AI. I know we're in the big data AI regime, and most AI operations are beneficial to humankind and to enterprises. Predictive analytics, that's the way to go. But the law says that the citizen has a right to what they call human review. So in the event that an AI decision is harmful to the individual, that individual has a right of appeal. They can ask the enterprise to, review that decision using a human rather than an AI process. Of course, if the human arrives at the same decision as the AI process, so be it. I mean, the issue is not that the decision must be changed, but rather that the citizen has a chance to appeal and have a second opinion. The citizen also has a right to complain, of course, to the enterprise, to the processors or the regulator. They have a right to, block marketing messages. As an enterprise, of course, you'll be worried about this, but you need to be clear and explain to the citizen if you block this level of engagement or share of your data, what does it mean? Okay, so that it's a two-way affair. The citizen is aware of the implication as they make that decision, that if I block my marketing opportunity, I probably stand to lose a list of the following benefits. But if I sustain that, so I stand to gain another list of benefits. There's a right to data portability. And I'll use Safaricom. We probably, all of us have M-Pesa or mobile money, and we've used it over 5-8 years. So the right to data portability says that whereas Safaricom keeps your financial transactions, you also have a right to it. You can decide to tell Safaricom that I need you to prepare my 3 months M-Pesa transactions in a way that I can download it into Excel, or in a way that I can move it to your competitor, whether that may be Airtel or Telecom Kenya, and vice versa. So suddenly the citizen can speak. The enterprise no longer, has 100% control or limited control to the data. Rather now it's a shared regime where each has a list of rights that is outlined in the law. Another right that this law gives is the right to be forgotten. I can tell Safaricom that I'm moving to Airtel and I want you to delete all my information. So I have a right to be forgotten. Of course, Safaricom or any other enterprise may not be happy with that decision, because data is, as they like saying, is the new oil. So there is a middle ground where the data commissioner will say, you can keep that data as long as it's anonymized. In other words, you can ensure that Walubengo's historical data with Safaricom exists, but the identifier to Walubengo is sort of, juggled up so that nobody can relate it to me. So those are some of the middle ground interventions that are possible. The right to security safeguards, I think most enterprises are okay or are aware of that. The right to security safeguards in cross-border. So there is a clause in the law that says that as an enterprise, you need to be very careful about sharing Kenyan citizen data with companies outside Kenya, particularly companies that exist in jurisdictions that do not have similar laws. Our neighbor, I'm not sure Uganda has passed their law. Last time I checked, they were discussing it in parliament. So if you're doing business with Uganda that requires you to transfer Kenyan data to Uganda, the data commissioner will want to have a look at that process. They will not automatically block you from sharing the data, but they will demand that your Ugandan counterpart has put in writing a contractual obligation to protect the Kenyan citizen data to the same level expected as the Act provides. The citizen can withdraw consent anytime. What that means is enterprises must redo their business processes to allow that a consent given 6 months ago can be reviewed. And when it is reviewed, what happens to the data? Do you anonymize it or do you delete it? So you need to think through what happens in order to comply with those regulations. Inform the data. Okay, now we're on the data controller. You realize that the rights of the data citizens come first, the data subjects. It is upon the enterprises or the data controllers to put in place processes and procedures to achieve or to facilitate the data citizen rights. So what does the enterprise do or the data controller do? They must inform the citizen about their data processing activities. They have to specify the purpose for collecting that information. They need to update the records, make sure they're available for scrutiny by the data commissioner when and if required. The enterprise should also make sure that the data they're collecting has specific consent. Sometimes it's implied consent. For example, if you approach a supermarket and pay for the goods through your Visa card, that is called implied consent because you removed your Visa card through your own volition. So it's implicit consent that you really want to share that information. But where you're going out direct, for example, eliciting feedback from citizens, you need to make sure that you have gotten the consent before you proceed. You also need to notify the regulator of any data breach. So in the event there is some violation, maybe there is a data leak, personal information has been hacked, it's a requirement that you inform the regulator in the shortest time possible. If you don't, you expose yourself to fines. Data controllers must register with the regulator, and then they have to think of designating a data protection officer, somebody that the regulator can engage with on behalf of the enterprise. You also need to do data protection impact assessment. This is a standard report that the regulator will demand, preferably done annually. They will expect that you have internal data protection policies and procedures designed to meet the data subject rights. Many companies already have privacy documents or privacy notices describing to the subject, to the data subject, how they're handling the personal data. So companies need to review the same in light of the Data Protection Act. Perhaps the current privacy notices are, biased towards the enterprises. They need to be tweaked to begin to be biased towards the data subject. I'll go to the next one. I'm seeing I'm running out of time. The key principles. The hierarchical of law, already privacy is anchored in our constitution. So the law or the act that we came up with is giving life to the constitutional requirement, Article 31. And so they work hand in hand, the overarching, the act, and later on the data commissioner may come up with final regulation for each sector. For example, the medical sector may demand more tighter regulations than, let's say, the retail sector or the telecom sector. So you'll find that there will be finer tweaking of the law by way of regulations. The other thing with regulations is that they change often. As the data, it's within the data commissioner and the minister's prerogative without having to go back to parliament. They can issue regulations as and when it's required. So the Act had the following, key principles, and I'll just run through each of them. Fairness and lawfulness. Before you collect data, make sure that there's a legal backing for it. It could be through consent, it could be contractual. Just make sure that you can explain to the data commissioner why and how you came to start collecting that information. The collecting has to have a specific purpose. In other words, you cannot collect for one purpose and use it for another. A good example would be the Electoral Commission will collect the voters' data, our biometric fingerprints and what have you, for purposes of elections. The Electoral Commissioner cannot then change the purpose and share that information for another purpose. Just to think of one, they cannot then share that information with, let's say, an agency like police. You cannot change electoral data into criminal purpose. And if that was your intention, then you needed to have said so from the word go, so that people make their minds accordingly or take you to court. The next one is transparency. Enterprises should be open with their data subjects. Who is collecting your data? Is there a third party they're sharing the information with? So those things need to be clear in the data privacy notices. Data minimization, try to be conservative on how much data you need from the subject. The key principle is don't over collect. And this is good business, because in terms of data security, the less data you have to protect, the better for you. Because if you've over collected data, you are basically exposing your surface area, the area to which hackers can harvest information. So if you keep a minimal footprint of data, you are indirectly securing information. Storage limitation, you can't collect, you can't keep data indefinitely. You need to define policies that say we'll keep it for 7 years, for 3 years, for 1 year, whatever it is. Let's have a policy on the same internally that defines why you chose 3 years and not 7, or vice versa. And more importantly, stick to that policy. The data you collect needs to be accurate, so the citizen needs to be able to access it and observe any changes that they want you to correct. Confidentiality, the data needs to be secure the traditional way, confidential, integrity, and availability. And finally, accountability. The enterprises or data controllers must be in a position to demonstrate compliance to the data commissioner. So the obligation, the effort is on the enterprise. If the data commissioner comes knocking, the onus is on the enterprise to demonstrate compliance. So there needs to be internal processes to ensure that when that data commissioner is in office and wants compliance reports, they are actually available. The Act has 50 pages, but in general, it covers what I've covered: the principles of data protection, the rights of the data subjects, the obligation of the enterprise. It has clauses on cross-border data transfers. It also defines the establishment of the data commissioner's office. Implementation schedules, we had put some implementation schedule. We thought that the law will be implemented in stages. but when it went to Parliament, they removed the implementation schedule. So the law is active from last year, November 2019. So companies should be compliant since then. What does it mean for enterprises? You need to have a data mapping process, understand how you're acquiring data, how you're storing it, how you're processing it, and how you dispose of it. From the perspective of the data subject. Okay, using data protection impact assessments, you're able to define that type of, process. You may need to appoint a data protection officer. It's possible that one company can share a single data protection officer. It's not a must that each company must have their own. There are not many to go around with in the first place. You need to take note of data transfer between Kenya and other countries, and then have procedures in place to issue breach notifications within 72 hours. I've put a few slides that go deeper into that. I'm hoping Ken will share the slides so that you read through. I want to just go to these 2 slides, that maybe 4 slides. What are the risks for companies? Given the Data Protection Act, companies will incur compliance cost, because to be compliant is not free. It will cost you to re-engineer your business processes. It will cost you to do capacity building for your enterprises. So there is a compliance cost to that. You also need to think through if you're in the big side, how does the AI, that decision that are being made, how do they impact the citizen? And do you have internally a process for appeal? In the event the citizen comes and says, this decision didn't favor me, do you have a process for human review? You need to keep track of clause 50, which allows the cabinet secretary to decide which data cannot leave Kenya. This law is largely pegged on the European Union GDPR, which has forced data companies to be compliant. Look at Facebook that I've shared here. You can see the privacy notice. It talks about the principles. It's communicating to the citizen about how they use the information, whom they share the information with, how the user can manage the data that is shared, etc. So if you're an enterprise, you need to be thinking of similar, communication strategies. Another example is Google. They have given power to the user to decide, to tweak how Google uses their personal information. Same with Twitter. You can see on the example for Twitter, it even gives you an opportunity to download all the tweets you have really shared over the last so many years you've been on Twitter. You can tweak a lot more privacy settings to your satisfaction. So in concluding, we just say that the law is there, but it's just the beginning. There's need to have a lot of capacity building at the enterprise level, as well as the judicial, prosecutorial, and data commissioner level. Even the data subjects need to be aware, and that's why I'm happy that most of you found time to log in, because it's an awareness process for everyone. The time to be compliant is now. We hope that we shall be so aware of our rights to the point where you can have a look at my last slide here. This 6-year-old, or is it 5-year-old, is asking the teacher, before I write my name on the board, he needs to know how she plans to use data. So a time is coming. Time is coming when the citizen will be that much aware. And if your organization is not at a level where they can engage with such an enlightened citizenship, then you probably may end up closing shop. With that, I think I'm done. Back to Ken. Thank you so much.
Thanks, John. That was great. As you
Yeah.
said, it's not just on an enterprise level, but citizens also need to be aware of their data and what is data and what is considered to be data. So thanks for taking us through that. We have quite a few questions here from our audience. I'll just go through the list and give you an opportunity to answer them.
Okay.
And then we can close out. So the first question was from Dirk Jan Koolman. With government not having put in place data commissioner, actually, I think there's a similar question from Amrit, so I'm just going to combine those.
Yeah.
What will happen? Any enforcement foreseen, or will it be Wild West? If you think they will enforce, how will that be done, and who will they pick? And Amrit has a similar question, which is considering there is no appointments to the Data Protection Commission officer, how enforceable is the Data Protection Act and its provisions that was launched in 2019? So I'll let
Okay.
you answer those questions before we get to the other ones.
Okay. Thanks for those questions. The government advertised for the data commissioner job, I think 3 months ago. So it's true they have not yet appointed one. However, as I said earlier, that the act became effective last year. So what this means is that the data subjects enjoy those rights even in the absence of the data commissioner. The way the law is structured is that in case of a complaint or a breach, the first point of call is the enterprise or the data commissioner. No, sorry, the data controllers, the enterprise. If the enterprise does not answer the issues to the data subjects to their satisfaction, they have a right now to go to the data commissioner. And of course, the data commissioner is not in place. However, if the data commissioner does not answer the data subjects to their satisfaction, they have a right to go to court. Is that in the absence of the data commissioner, if a data subject launches a complaint to an enterprise and they're not happy with the answer, they have a right to go directly to the courts. So that the enforcement agency in the absence of the data commissioner is your court, your magistrate court. So that is the answer to that question.
So meaning that the citizen has a right anyway to fight anything.
Yes, yes.
Based on the Constitution. So there's another question from Dirk. SAFCOM still not masking MSISDN.
Sorry, you broke off a bit.
Can you hear me now?
I don't know if it's my end or your end, Ken.
Can you hear me? Can you hear me now? Can everyone hear me on the?
Yeah, you're back.
Okay, great. So SAFCOM still not masking MSISDN for Leap and M-Pesa, thus resulting in unsolicited SMS spam by merchants. Scary still insisting that you leave PII, personal identifiable information, and sometimes even documents without assuming data controller responsibility. Data subject is stuck as both Green as well as Ascari are handling with impunity. What is the point of raising a complaint to non-existent commissioner based on your last question, or your last answer?
Okay, yeah, okay, I may not comment on Safaricom, but the one of the Ascari at the basement or ground floor is quite familiar to all of us. We leave our personal information there as we go to the offices or to meet whoever we have to meet. We have no clue what the Ascari does with that information. So it is definitely a point of concern and a potential point of vulnerability. The data controller there is actually not the Ascari. The data controller there is the owner of the security firm, whether it is Securico or whoever the offices have contracted to institute security measures. So what this means is that if the data subject has some complaints to do or they have someone to blame, they just need to go to court and raise the concern about how they feel their data is being handled by that security firm. The law is there, but to breathe life into it requires participation from all stakeholders. The court cannot, through its own volition, wake up and start policing anybody. The court will sit back and expect citizens to wake up and demand their rights. And thereafter, the courts will then accord those rights. But for as long as we become meek and humble and just, comply to some of these things without question, then we're not helping the regime and ourselves. So the owners, in the absence of the Data Protection Commissioner, it's up to us. But once the Data Commissioner is in place, the law provides that they can act on our behalf. They will not have to wait for someone to complain. They will have a register of all the, key data controllers, and then they will be demanding compliance accordingly. So
Great.
I would say.
Great, awesome. So on the next question from Diana Ditaka. Hi, thank you so much for this session. I recently started learning more about the subject and have developed a passion for it. As a lawyer, I'd like to know what training is available in Kenya to enable me to improve on skills and knowledge. Thank you.
I've not seen Kenyan companies beginning to train on this data protection domain, but globally there are some companies that are offering training in this space. I think there's one in the US, International Data Protection Association. You need to Google that. I'm also aware ISACA, also based in the US, they have some data protection or data privacy trainings and certifications. But in a nutshell, the domain requires that you have a blend of both the technical IT stuff as well as an understanding of the legal dimension. That's
great.
What I would say.
And we have a question from Neil Ribeiro. Neil is asking, can we give the citizen, I guess this is from an enterprise perspective, an all or nothing option? Example, either get marketing and other information or get nothing. In other words, do we have to give the citizen a menu to pick from?
Get nothing is an option. The issue is not that the data commissioner will force enterprises to give citizens something. No, that's not the issue. The issue is that the data commissioner will demand that the enterprise is transparent and informative enough to enable the citizens make the choice. For example, if your enterprise says very clearly in their privacy notice that if you sign up, you're going to get, the following 3 benefits. If you don't sign up, you're going to get none of them. That's enough. That's compliance. The problem comes in when you're signing up people without telling them what is in it for them, without seeking their consent, without being transparent that you'll share it with third parties. You're signing up people, collecting information about them that they're not aware you've collected. So that is where the domain gets murky. It's not that the data commissioner is forcing private sector to give freebies to citizens. It's going to force them to be transparent with citizens.
Great. And then anonymous, where does KYC and data protection meet? If running an e-commerce platform, I'm obliged to collect data from my customers.
Yes, you are. Again, the data commissioner will not stop you from collecting. What the data commissioner wants you to do as you collect that information, they want you to inform the citizen why you're collecting that data. They want you to inform the citizen how you will use that data. They want you to inform the citizen how you're responding to data breaches. So it's all about transparency. Um, it's not about blocking enterprises from enjoying the benefits of the data economy. That by all means must continue, but the level of transparency must be there to protect the rights of the citizens. So KYC is in order as long as it's also compliant to the data protection law.
And John, you mentioned protecting the rights of the citizen, and now going through this pandemic, there's a lot of questions around data and trying to solve this problem.
Yeah.
And there's a question from Amrit Laburam. He talks about currently in Senate, a pandemic response and management bill has been proposed, and Section 5 of the bill provides that the bill is applicable upon the declaration of a pandemic, and it shall take precedence during any conflicts of law. If this law is signed into force, what is the place of the Data Protection Act and the rights and obligations contained within it?
Okay, I've not looked at the law, but I mean the Senate proposal, but even before I was to look at it, the Data Protection Act had already made provision for, public health situations or national security situations. So already there is a prescribed way anticipated where the citizen rights do not supersede public interest. So, for example, in the current COVID situation, patient tracking and all else that goes with it is quite a matter of collecting sensitive information. And you cannot have a data subject saying, you've got to get consent from me. Government must get consent from me before I tell them where I'm located. You cannot have a situation where the data citizen who is positive saying, I'm not going to disclose my location or my movements because the Data Protection Act requires that you seek consent from me. So already, even without the Senate expanding the issue, the data protection law was quite clear that citizen privacy concerns cannot supersede public interest. However, there are parameters within which that is applicable. For example, it's clear that that will work, for example, a certain period of time. And when that situation improves, then you default back to the standard way of operating.
Great. And we're just going to take two more questions before we close out. So from an anonymous attendee, are you guys planning anything about Haduma number data? I don't know where that falls in because as you are in the task force for the government developing the Data Protection Act, how does that play into that whole narrative?
Okay, the Huduma number was actually sort of progressing when we were in the task force. And we're lucky that over the last 1 year or so, it has been litigated. And I think the courts have determined instances where the government had overreached, and it has issued rulings for the government to continue its Huduma operation, subject to adhering to the data protection law. So the general message is that the Data Protection Act applies not just to private sector, but also to public entities. You cannot abuse citizen data simply because you are, in quotes, the government. As you collect our data, whether they be birth certificates or passport details or national ID numbers, you are going to do so within the confines of the law. So Huduma number is there, but it is going to operate within the Data Protection Act. Yeah.
Great. And from Josh M, to what extent are Kenyans affected by the new GDPR, or is it only limited to Europe?
Interesting. GDPR is largely European-based, but if you are a European citizen based in Kenya, and a Kenyan company interacts with you, it is assumed that that Kenyan company will protect the European citizen data. Of course, people will say, okay, how about enforcement? Because the European jurisdiction does not reach the Kenyan jurisdiction supersedes European. Yes, that's true on paper, but in practice, if the European nations want to take sanctions against Kenya government, they have a bigger economic might to do so. So whereas it's not in black and white that the Kenyan enterprises must follow the GDPR, it is by practice because these guys are a big economy. Think of it this way: Facebook, Google, they're American companies, but they have had to comply with GDPR because that's just how powerful that economy is, to the point where enterprises feel that if they want to engage with European citizens, they have to comply. On the Kenyan side, it's the same. If you want to engage with European companies, you need to comply with the GDPR, but because the Kenyan data protection law is adequate, it's more or less similar to the GDPR, we believe that if you have compliance from the Data Commission of Kenya's point of view, you're compliant, then the European GDPR law will consider that adequate. So that's how I will put it. Yeah.
Great. No, thank you. Thank you everyone for your questions. Before we close out, I just want to get your closing remarks, John. And, as we close out our session for Ajua Stay Alive and Thrive webinars. So I'll hand it over to you for your closing remarks.
Okay, thank you, Ken. And I want to thank the participants for staying with me. This is a new area for the Kenyan domain. And it's a learning process for, data subjects. It's a learning process for enterprises or data controllers and their processors. It's also a learning process for whoever that may end up being the data commissioner, the judicial area as well. And there is no shortcut. People must spend time, download the Data Protection Act, download the data protection policy, and start reading. Get familiar with the expectation. Otherwise, you expose yourself to the risks of non-compliance. Thank you all.
Thank you so much. And John, this was very, very informative. You're getting a lot of praises from folks saying this is quite informative. It's a great webinar. This has been a great webinar. Kudos. More of them will be welcome. Thank you. I look forward to learning more on this. So the subject matter is very relevant in this time, right? And I think it's actually more evident because, as you mentioned, because of the pandemic and contact tracing and all this different things that to do with data. So really thank you. And thanks to all our attendees, our panelists, about joining us. Ajua Stay Alive and Thrive webinars. And as we say, we offer these webinars just to build context around things that everyone's talking about or having discussions, but now to have a very good session and community around this so we can actually thrive and move through this pandemic. Next session we'll be having is to the CEO of Trigger, who will talk to us about digital transforming service delivery, a supply chain model, specifically in agriculture. And that will be by Peter Jongo from the CEO of Trigger. So thanks everyone. Have a great day and enjoy the rest of the week. And we look forward to you joining us next sessions next week. Thanks. Appreciate it.
Thank you. Bye-bye.